I have been discussing uh, right of the preemption or haqq sufa. Yesterday, I tried to explain the concept of haqq sufa. What is the basis of right of haqq sufa? What are the traditions or the saying of the Holy Prophet uh, that have given rise to the right of the preemption or haqq sufa? And I also made the sincere effort to uh, give the account of the historical origin or historical background of the law of the preemption, particularly in Indian context. And then I explained what is the meaning of the haqq sufan according to the jurist on the subject of Muslim law. I referred the definition of the various jurists explaining the meaning of haqq sufa. I try to explain the meaning of the haqq sufa with reference to the various definitions given by the various jurists on the subject of the Muslim law. Then I try to explain the meaning or the definition of the haqq sufa as propounded by Justice Mahmood in Govind Dayal versus Inayatullah, and how the definition of the haqq sufa formulated by Justice Mahmood differed from the concept of the haqq sufa or right of the preemption as explained by Calcutta High Court in Sheikh Qudratullah versus Mohini Mohan Saha cases. Reference was also made of the important leading case on the point with regard to the summary of the law of the waqf or the basic elements of the law for preemption, not waqf but preemption. And the leading case where in the entire concept of the law for this preemption has been summarized by the Supreme Court. That case is Bishan Singh versus Khajan Singh case. Then, dear learners, I have also explained what is the nature of haqq sufa. Particularly, what was the view of Calcutta High Court in Sheikh Qudratullah versus Mohini Mohan Saha. In Sheikh Qudratullah versus Mohini Mohan Saha case, Calcutta High Court took a different view, and court said that right of the preemption is not a right of substitution, it is a right of the repurchase, not from the vendor but from the vendee. And Calcutta High Court also in its judgment pointed out that the right of the preemption does not arise after the sale which has been executed by the vendor in the name of the vendee, because on the execution of the sale, owner's full ownership passes out of the vendor to the vendee, and vendee becomes the absolute owner of the property which has been transferred by the vendor by means of the sale. Therefore, a right of the preemption may be before the sale, but after the sale the right of the preemption is lost, and preemptor cannot claim the property back from the vendee because he has already become the full owner thereof pursuant to the sale deed which has been executed in consideration of the price agreed upon between the parties, and therefore the preemptor will not be entitled to step into the shoe of the vendee once a final sale deed has taken place between the vendee and vendor on certain agreed price. Ladies and gentlemen, then came the judgment. After several years of this judgment, the matter of preemption came for consideration before a bench of Allahabad High Court in famous case Govind Dayal versus Inayatullah case. Ladies and gentlemen, in Govind Dayal Inayatullah, Justice Mahmood, on the basis of authority of the Hidayah, not only formulated a very technical working definition of the term preemption or haqq-e-suba, at the same time refuting the opinion or obiter dicta of Calcutta High Court in Sheikh Qudratullah case, held a different view so far as the nature of the right of the preemption is concerned. And Justice Mahmood in Govind Dayal versus Inayatullah case held that right of the preemption is a right of substitution by the preemptor from the vendee. Meaning thereby that Justice Mahmood said that it is not a right of repurchase, rather it is a right of substitution. Meaning thereby, once the right of the preemption arises, claiming the claiming the property of in the exercise of the right of the preemption, the preemptor is fully entitled to dislodge the vendee from the property already sold to him for certain price, and at the same time the preemptor will be entitled to step into the shoe of the vendee for the price the property was sold to him by the vendor. Therefore, Justice Mahmood said that it is not a right of preemption, but it is not right of repurchase, but it is a right of substitution, entitling the preemptor to dislodge the vendee from the property adjacent to his own property and will be entitled to be substituted for the vendee. Ladies and gentlemen, I also made the point clear that Justice Mahmood also clarified that the right of preemption arises only after the final sale of the property in question. Of course, the right of the preemption is a pre-existing right having regard to the situational location of the properties in question. It is the pre-existing right of one co-owner against the property of the other co-owner, or it is the pre-existing right of one co-sharer against the property of other co-sharer, and this right will be available, or will be right will be exercised or will arise. This right will arise only in the event of the sale, that is when the sale deed of the property has been finally executed by the vendor to the. So, it is the sale, the final sale of the property in question basically gives rise to the exercise of the right of the preemption. Before the sale, right is pre-existing. Preemptive right is pre-existing, but this right can be invoked and can be exercised to claim the property back by the preemptor from the vendee only when there is a clear proof of the sale of the property by the vendor to the vendee. And therefore, Justice Mahmood on this point also did, because the Calcutta High Court held that right of the preemption can be claimed before the sale. After sale, the ownership has passed on from the vendor to the vendee, and therefore vendee has become the absolute and full owner of the property, and therefore he cannot be dislodged. But Justice Mahmood said that no, right of the preemption is pre-existing right having regard to the situational existence of the two properties which are in conjunction of each other. But this pre-existing right becomes active right only after the execution of the sale deed by one co-owner without informing to the other co-owner to a stranger. Because the question of the inconvenience, question of the disturbance, question of the intrusion of a stranger in the property will arise only when sale deed has been executed and the vendee has taken over the possession of the property. And further, Justice Mahmood held that right of the preemption is available only against the immovable properties. Maybe house, maybe building, or maybe landed property, but the property should be the immovable property by nature. Number one, property against which the right of the preemption can be exercised by the preemptor in the event of the sale of it to a stranger by passing to the preemptor only against the immovable property. The immovable property means here maybe the house, maybe the building, or maybe the landed property. Against the immovable property, it may be orchard, maybe garden, particularly garden, orchard, house, building, or maybe the landed property, plot of the land. But in most of the cases, the rule is that the property should be immovable in the form of the house, orchard, or garden. Regarding the open land, also there is a dispute. There is a divergence of opinion because right of the preemption basically is based on the right of convenience. Because when the properties are in coexistence, owner of one part is selling to a stranger by passing to his co-owner as or co-owner or participant in the appendage and immunities. So as soon as the sale is executed and another person is allowed to become the owner thereof, the other being the stranger may be a source of inconvenience to the partner who was having the preferential right to purchase this land which has already been sold. And therefore, ladies and gentlemen, this right basically is based on the convenience of the preemptor. And in the open land, until there is construction of the house, building, or there is some other properties already in active use, possibility of inconvenience is remote. Therefore, will it be a subject matter of the preemption or not? That is a subject of dispute but it is also included within the meaning of the subject matter of the pre-emption. So, a right of the pre-emption arise only in the case there is transfer of the property by sale. So, there must be a transfer of the property, and transfer must be by sale. For example, here now here A and B are the co-sharer of the property X. This is the property X and it is owned jointly by A and B. They are the co-sharer or co-owner in the property X, for example. By implication, share of the B is maybe 50% and share of the A may in the land may be 50%, means both may be the 50% sharer or owner in the property X, or maybe, and this property may be a constructed house. For example, this is a constructed house or this is a orchard garden, and the entire area of the garden or orchard or the house is in the co-ownership of A and B, and A and B are the co-sharer therein, and share is undivided. But as per rule, 50% is share of A and 50% is the share of the B. Now, gentlemen, in case rule requires that if A is wishing to sell his share in the property X, as per rules of the Muslim law and law of pre-emption, he is required to make the offer of the sale to B. If B refuses to purchase it, then he can sell it to anybody else, maybe the C or maybe anybody else. But without any information to B, if A makes the sale of his portion of share in the property X to C, and sale deed is executed in the name of the C without any information to the B of this entire transaction, as soon as the information of the sale by A to C of the share in the property X comes to the notice of the B, B is required immediately to place the first demand, makes the first demand, and after that he will make the second demand, and after second demand, basically he will file a suit claiming the property from the C and will plead that he is entitled to be substituted for C and C should be dislodged from the property, and if otherwise court is satisfied from attending facts and circumstances and pleading of the B, the B will be here preemptor and C will be vendee, A will be vendor, and B will be entitled to be substituted for C in the exercise of his right of the pre-emption. But this right is pre-existing. This is the pre-existing right of the B against the property of A, against the share of the A, and it is the pre-existing right of the A against the share in the property X of B. So, whosoever is either A or B, whosoever is intending to sell his portion of the share in his share in the property X, he is under the obligation of law pre-emption to give the information of his intention to his co-sharer, that may be A, vice versa. But right of the preemption is pre-existing because of this situational existence of these property, because both the properties are in conjunction, they are adjoining, they are in the co-ownership. Because of these reasons, this right is pre-existing. But the right will become active only after the sale of either this part of the house property or this part of the property. This part is in the ownership of A, say for example this part is in the ownership of the B. Both are co-shared and they have got the property as joint owner and are still joint owner, and therefore one joint owner may claim this property after the sale, only after the sale. So sale should be final and sale should be the sale of the immovable property. After sale, this right of the preemption will become active and can be claimed by whosoever is the preempted in this case. Therefore, the right of preemption does not arise in the following types of alienations of the property. Following types of the alienation of the property. Because, ladies and gentlemen, at the cost of the repetition, I may remind all of you that right of disposition is integral, is an important right of the owner in respect of the property he owns. And any person who is owner of certain property, he has got indefinite right of disposition, unlimited right of duration, indefinite right of alienation, indefinite right of user. So, one who is the owner of certain existing immovable properties, being the owner, he has got the indefinite right of alienation, means he can dispose of his property by any legally recognized means. So, law recognizes various legal means for the disposition of movable and immovable properties. The various modes of disposition, alienation or transfer of the ownership of the property by one person to other as recognized under the Muslim law particularly, are one can alienate his property by way of gifts. I have already explained what is the gift or hiba under Muslim law. Basically, hiba is immediate and unconditional transfer of any specific property without any consideration by one person called as donor to accepted by or on behalf of the other known as donee. This is the gift, basic. So, gift is also a mode, recognized mode of transfer of the ownership in a specific property or transfer of specific. Sadaqah. Sadaqah is basically a charity. In order to gain the divine pleasure, a Muslim, not only Muslim, even anyone can give away something to any needy, poor, downtrodden, underprivileged person So when somebody makes the charity of his certain property items are in cash to any poor or downtrodden person or poor person, and the objective is to gain the pleasure, then such type of the charity is called as sadaqah. Is called as sadaqah. Under Muslim law, sadaqah is a kind of charity and is permitted to be made by the wealthy person in so that those who are resourceless poor person may fulfill their arising economic needs. There is no limit of sadaqah. Sadaqah may be given 1 rupees or may be given 100 rupees. It depends upon the person who is doing the charity. But in charity also basically the person is passing on his item or property. Normally movable properties or movable items are given as a sadaqah. But this in sadaqah we say, for example, if I am having the 100 rupees note, I am the owner of this 100 rupees note, having the indefinite right of use. But at the same time I have also got the right to give away my 100 rupees to a poor person, and as soon as the poor person is 100 rupees 100, he becomes the owner thereof. So ownership of 100 rupees is instant transferred. Waqf is another mode of the disposition of the property, already I have dealt with. Waqf is the permanent dedication by any person of any property, movable or immovable, for any purpose recognized by Muslims as pious, religious or charitable, and also includes waqf by user, grants, patta, deed, also waqf al-awlad to the extent it is for pious, religious and charitable purpose. Inheritance means once there is a death of a person, owner, on the death, as soon as there is a demise of the owner of certain properties, on the death, the ownership right immediately passes it passes on from the deceased, and it goes to the legal heirs of the deceased. Means here legal heirs means person legally entitled to inherit or succeed the property. So in inheritance also there is a disposition, means ownership passes out of the deceased and goes or vests in the legal heirs. So say for example, if there is X is a person owner of this house. Now he has got a son, a daughter. There is a death of the X, suddenly the X dies. So as soon as X dies, immediately on his death, the ownership of this property, say house X, will devolve upon his son and daughter according to the rule of Muslim law of inheritance. Son will become the owner to the extent of 2/3, and D will become the owner, or property will go to the extent of 1/3 to the D as per rules of the Muslim law. Lease, mortgage, conditional sale, these are the various modes of transfer or disposition of the property which are also recognized under Muslim law. But here the point which I want to make to the audience or to the learners is that right of the pre-emption arise and can be claimed only on the final sale deed on the final execution of the sale deed by one co-owner bypassing to the other co-owner in the name of a stranger. Therefore, the right of pre-emption does not arise in the following uh, types of the alienation or transfer of the property, that is by gift, sadaqah, waqf, inheritance, bequest, lease, mortgage, they will not give rise to the right of the preemption. And therefore, here in the same example, suppose A is the owner of this plot, this piece of 50% in the house. B is the sharer in the to the extent of 50% in this house. Say for example, it is a house, or it is a garden, or it is a orchard. Now, if A makes the gift of his portion in the garden, say for example to a stranger C, without any information to the B, later on B comes to know about the sale, about the gift made by A to C of his portion of his share in the property X, and wants to claim it back from the C. In the exercise of the right of the preemption will not be there, and therefore B cannot do anything, and the ownership of the share of A in the property X will pass on from A to C on the delivery of the possession of the subject matter. Means as soon as the C is put into the constructive or actual possession of this portion of the property X, now donee will become the will step into the shoe of the donor, but here the co-sharer or co-owner B will not be entitled to claim the property in the, because right of the preemption arises only in the case of sale of any immovable property without informing to the owner of adjoining property. Same is sadaqah. If somebody has given this portion in sadaqah, or if somebody has, A has made the waqf of this property his share. Now, against the gift, sadaqah, waqf, inheritance, bequest, lease, even though in perpetuity, mortgage and conditional sale, the this right of preemption does not arise. So it must be crystal clear. Therefore, right of preemption is very feeble rights, has been repeatedly said by the jurists on Islam. Therefore, Waqif has no right of preemption as somebody this similarly in the event of the gift, there is no right of preemption. Friends, another point that is necessary to be clarified, that against whom the right of preemption arises. If all parties are Muslim, there is no problem and law of preemption will be applicable. Means when under what circumstances law of preemption becomes applicable. Rule is very clear that suppose this is the property in the co-ownership of A and B. Property X, property here A is entitled to the extent of 1 to 2, so is the case with B. A has sold his property, his share in the property X to C, a Muslim, say for example, a Muslim. Now here, of course, right of preemption arises because she is the stranger, but he is Muslim. Will the law of preemption will be applicable here, because here vendor is Muslim, vendee is Muslim, and preemptor is also a Muslim. B is the preemptor because A has sold his share in the property X to C, a stranger who is also a Muslim. Here no problem. Law of preemption will arise according to Justice Mahmood in Govinda Al-Rasid in Ayatullah. There is no problem there. But it cannot be applied or will not be applicable in the following cases. Consequently, no preemption in following cases. What are those following cases? I would like to explain one by one. or difference in the religion. This if all parties are Hindus and there is absence of relevant custom, means if the vendor is Hindu, vendee is non-Muslim, and pre-emptor is also Muslim, non-Muslim. In this situation, because all the parties are non-Muslim, Hindu, therefore right after pre-emption, if all are Hindu and there is absence of relevant custom, then law of the pre-emption will not be applicable. If the vendor and vendee are Hindus, if all the parties are Hindu, law of pre-emption does not arise, because it cannot be, law of pre-emption cannot be applied in the following cases. Number one, where all the parties are Hindu except where custom permits. If vendor and vendee are Hindus but pre-emptor is Muslim, law of pre-emption does not arise. If pre-emptor is Hindu and the vendor and the vendee is Muslim, will not apply. If the vendee is Muslim and pre-emptor and vendor are Hindus, law of pre-emption does not arise. If the vendor is a Muslim and pre-emptor and vendee Hindus, law of pre-emption does not arise. This is so because Muslim law is personal law and not common law of the land, and the right and obligation must be reciprocal. What will be the position of the pre-emptor and vendor are Muslim but vendee is Hindu? The above statement, the following statement about the religion of the three parties may be tabled as follows to better appreciate the position. Vendor, vendee, pre-emptor, right of the. If the vendor is Muslim, vendee is Muslim, pre-emptor Muslim, yes, right of pre-emption will arise. Hindu, vendor is Hindu, vendee is Hindu, and Hindu is the pre-emptor, depends upon the local custom. Vendor is Hindu, vendee is Hindu, and pre-emptor is Muslim, no law pre-emptor will not arise. Where parties, one of the parties is Muslim, other is also Muslim, and the pre-emptor is Hindu, no right of pre-emption does not arise. If the pre-emptor is Muslim, vendor Hindu, and pre-emptor Hindu, law of pre-emption will arise. No Muslim, if the vendor is Muslim, vendee is non-Muslim, this is another situation, and in this way the right of pre-emption will be exercised by the vendor as well as the vendee.